basically been told, just to give you a rundown of the reconsideration process. After that, open to any questions, as Mike said. I didn't prepare a slideshow. I wasn't aware I had to put it.
You don't have to, it's optional.
Yes. So I'll just talk of the legislation as it's put in. I trust that everybody know where the DA is at. At this stage, refused on the date here. Refused on the 20th of May 2015. So under section 190, the proponent or the applicant has the right to apply for reconsideration, or alternatively to appeal the decision at the ACAT tribunal. In this case, the proponent indicated that they intend to lodge a reconsideration application.
Excuse me, can you talk about
Okay. Right. In this case, the proponent indicated that they intend to apply for a reconsideration application under section 191, and the proponent can apply for a reconsideration if the decision has been refused, as in this case. There are certain other provisions, I'm not going to go through them. The application needs to be lodged within 20 days, 20 working days from where the decision has been made, or alternatively on such further time as allowed by the Planning and Land Authority. In this case, the Planning and Land Authority has extended the time until the 31st of October 2015. The reason for that lengthy extension is the applicant, proponent, donor group indicated that it's quite a complex design process. It's not unusual for a complex decision like this that would provide a lengthy extension. So, just continuing on. Once the Planning and Land Authority receives the reconsideration application, then it can either make a decision to substitute that substitutes the existing decision, or it can confirm that decision. It can only do one of those two. The other thing you need to keep in mind for reconsideration application, can only be made once. So the developer is not allowed to have another bite of the cherry, if I can use that term, and so they're restricted to one application for reconsideration. And that also partly contributes to the time frame that we allow for them to prepare their application.
Can they appeal?
Pardon?
Can they appeal?
They can still appeal it.
They do get a second bite.
Under the appeal process, yes, but that's a process outside of the Planning and Land Authority. So we would just be a party to that, if that's the case. Once we receive that reconsideration application, the Planning and Land Authority under the legislation doesn't need to publicly notify the reconsideration application, but we must give written application to anyone that made a representation on the original deed. So every one of those representatives, I think it's 56 from memory, would get in writing notification that a reconsideration application has been lodged, and we have to allow reasonable time, not shorter than 2 weeks, for those people to comment on that reconsideration application, and to make another representation if they wish to do so.
So, excuse me, they're allowed months with a big silence before they come back, and we're allowed 2 weeks?
Yeah, I question
Yes.
that too.
Yes. The Act says not shorter than 2 weeks. So we can take that in consideration. So that means, in theory, the Planning and Land Authority can extend that time frame depending on what's put in front of us. And at this point, I just want to say there is no application. We haven't received an application, and we haven't even been shown an application by the proponent to this date. Yes.
With the reapplication, is that exactly the original proposal resubmitted, or are they allowed to have variations?
They are allowed to have variations to it, and that's, in my view, obviously the reason why they saw that extended time frame. On the other hand, nothing stops him from putting the original application. We don't know what's going to be lodged yet at this stage in front of us.
So if you rejected this one, can you then put in another application?
No.
A fresh one?
A new DA? Yes. You can put in as many DAs as you want to, and the Planning and Land Authority has to consider it.
So what's the advantage of asking for an extended period to vary an old one when you could just put it back in again as a fresh DA?
Probably the advantage in that would, I don't know from DOMA's point of view, just from the Planning and Land Authority's point of view, the advantage would be that the issues have been narrowed down to certain issues. That's what I would think. In our refusal, we give reasons for our decision, so they would want to respond to those reasons. With a new DA, the applicant would potentially run the risk of opening up new issues. Under the reconsideration process, we have to look at the new proposal as well as what was in front of us during our previous decision. Something else about the reconsideration process is that we have, the Planning and Land Authority will need to make, has only 20 working days to make a decision under the legislation, but again, that time frame, so the Planning and Land Authority got 4 weeks to decide the reconsideration application. That time frame can again be extended by mutual agreement between the proponent and the Planning and Land Authority. So they might put it in on the 31st of October or whenever before that time frame. We get to the end of our 4-week time. Before that, we might ask the proponent for an additional week or 2 weeks to consider it. Normally we find with these sort of DAs, the more complex DA, that we need at least 2 weeks additional time, particularly if you have a number of representations.
What if they say, no, we're not giving you more time?
Then the Planning Authority will have to make a decision with what's in front of them. So, and saying that you potentially are under risk.
So it's not a mutual agreement then, really?
Yes, but then the Planning Authority's got the option to confirm the original decision again, to refuse the deal. That's, so you would think it's to the advantage of the proponent to agree to that extension, if that happens.
Can you update the parking at all? The alternative parking? Do you have any updates on the alternative parking?
The temporary parking?
No,
Yeah.
we've been advised that they are working on that, but we haven't been told what the solution would be to
They've been
the
working
offsite.
on it for a couple of years.
Yeah.
So there's no actual agreement between Amalgamated and Dome Group?
I can't comment on that because I haven't been party to those negotiations, so I really don't know.
Do you know anything further about if that doesn't go ahead? Do you know what the plan is?
No, I
Is it
don't.
to go back to the cove? In front, like in between the pool and Angel Street?
Yeah, that is something they can obviously put in front of us. We will have to consider it once we get the application. But I really don't know what the solution to parking would be at this stage because we haven't seen a proposal. Part of that proposal would involve answering that question, what they're going to do with the temporary parking arrangements.
That's a critical issue for both the residents of Dickson and Downer and small business such as Jay, and I can't believe that you've come here tonight and you don't know where the discussion is.
Is there like a plan C, or is a plan C being worked on? Because obviously nobody wants the plan A, which was in between the pool and Angel Street.
I'm aware that
Is there your department that would work on a plan C, or is it another department?
Are you able to take that back and get
yes,
get an
I'll
answer
probably
for us?
take that
Okay.
on notice. Yes.
I think it sounds like it might be one of the other areas, but I think just if you
Yes.
can, please relay back that we're very concerned about what's
We will
happening
know
with
that.
temporary parking and really would like to get a solution as soon as possible because it really has been dragging for a long
Yes.
time and that's why people are concerned about it,
Yes.
so, yeah.
Yes.
So if there's no temporary parking solution, does that mean you knock the whole development down? Because they've got no solution to where people are going to park temporarily?
Well, obviously it will affect the decision. I can't say that in itself will make a refusal, but it will obviously play an important role. It's part of the impacts also we consider as part of the development.
Can I ask George be allowed to finish his presentation because he's not that long
Yes.
to go?
There's not much to say. Another thing to remember in terms of reconsideration is that the decision maker is not the same person that decided the original decision. So I've decided the original decision. It must be somebody else. Our standard operating procedure in planning land parties that it's normally somebody more senior than at a more senior level that will
Any indication of who that'll be?
well, I can't give you a name, but it will be somebody potentially more senior than what I am. So the decision will be taken at a very high level, if I can give you that assurance.
I'm noticing it's just before 1:45. I'm hoping, are you happy to wait for a few minutes? Yeah, okay.
The last thing, just after that decision, the reconsideration decision has been made, then the proponent obviously has the recourse to approach the tribunal with an appeal to challenge our decision, whatever the outcome is. The same. Yes.
Sorry, James?
Said anything about the businesses?
Please, can we hear the question, please? Sorry, just...
Well, I'm interested in whether is going to be an impact track or whether it's going to be the other one called?
Area.
That's quite important in terms of how the decision is made. So what's the answer on that?
Okay. The original decision was lodged in the merit track because the development is provided for in the development table. It doesn't meet any of the triggers of an impact track DA, so that's contained in Schedule 4. Once a decision is in a track, in a merit track, under Section 113, it cannot change tracks. It will remain in that track. So
which division was that?
Section 113. Section 113 of the Act.
So that would be why they want to have a reconsideration, because if they have to start again, we would argue it needs to be in the impact track. So we can't change it under a reconsideration.
The development we've seen before, it doesn't trigger any of the impact track triggers in Schedule 4. That's all I can say at this stage. So the only other alternative would be for, if it's a new DA, the Minister could potentially declare it impact track. That's a different process in itself. Yes.
Can I just go back to the timing that you were talking about before? We're talking about 31st of October was one of the critical dates, I think.
Yes.
We go October, November, December. December, January, we've all had this before.
Yes.
Important decisions being made in December, January, and hello, everyone's away on holidays. Is that something that you would take into account in terms of extending timeframes and so on? I mean, basically December, January is a wipeout, particularly as far as the community is concerned.
Normally over the Christmas recess we do extend our time frames. We take in consideration the nature of the DA as well, so that could be a consideration. But if it's over the Christmas, New Year break, over that time, just before Christmas and after New Year, then normally it gets that equivalent additional days added on in January.
I'd just like to point out that this DA was originally advertised starting on the 19th of December.
Yes.
And the deadline for submissions was, can you believe it, the 27th of January,
Yeah.
the day after a public holiday, Australia Day. So if something like that were to happen again, I think that would be incredibly outrageous.
Yeah, hopefully that wouldn't be necessary, because keep in mind we've got 20 days to deal with it unless we get an
Can
extension.
I ask, so the 5 months extension that's been granted to the proponent, presumably that means that at any point in that 5-month period, they can come in with their application and you then have only the 20 working days.
Correct,
Right,
Yes.
so they can drop it on you whenever they like.
yes. There is though what we call a completeness check process before that, so it's not that they're just going to drop an incomplete application on us. We will have a look before we accept the DA at the documents in
But in
front
other
of
words,
us.
everybody here who may have lodged a representation, of which I think there were 59, presumably 57 different representatives, since I believe I put in at least 2 submissions.
Yep. 59,
Right.
yes.
So any one of us, at any point between now and the 31st of October, which I think is Halloween, could suddenly find that we have just 10 statutory days, 2 weeks, 10 statutory days.
According to the statute provisions, yes, that's correct.
Does that seem fair to you when they get 5 months?
Can I get a point of order on that point? Just a quick point. You're saying the Act has 20 working days to respond. What you haven't said, I'm just asking for clarification, is there a period within that 20 days for public consultation, or is that...
That's incorporated in that time frame. So it's an extremely tight time frame for reconsiderations.
So you're actually saying there's 20 days for the... Once you put the note, once they lodge, you've got to get the notice out to everybody else,
Correct.
for everybody else to react to that, and meanwhile, in parallel to that, you're making your decisions because you've only got 20 days, unless you get it extended, of course. So that's what you're saying. That's the little window
No,
of...
the 2 weeks would
window of
start
consultation. You do put things out for consultation, because this is a...
Yes, but
No, it doesn't go to public notification.
it gets notified to each of the 59
Only to
representatives.
the representatives.
In other words, if you haven't put a representation in your,
Well, just to clarify that, the Act actually says that
Okay, and I'm just conscious of yeah. So I think that probably gonna have to be it, everyone.
I think that there is an
hang on.
option
I
in
think I've got enough of answers. I'll go to my second
Okay.
question.
Yep.
Okay.
The Act says the authority does not need to publicly notify a reconsideration application,
So it's optional.
so it's optional. And it also says talking about the persons that put in representations in the original application of 59 persons, we have to allow them reasonable time to make a representation that is not shorter than 2 weeks. So again, there's a degree of option in that. Obviously, in a DA like of this nature, I think it's highly likely that the planning authority will try and negotiate for additional time. And I think it's safe to say that it would be also in the interest of the proponent to agree to such a time frame.
Why do they have to agree?
They don't need to.
No, but it's your option, isn't it? If not less than 2 weeks, it's up to you.
No, I'm talking about extending the time frame for consideration of the DA.
Okay.
So,
Okay, Dennis.
Yeah, there is a period before when they put the paperwork in and before you actually lodge
yes,
that consideration. Can I suggest you seek the Minister's approval or whoever, that the moment you get that application, while it's being checked, you actually advise those 59 people that it is about to happen, so they have a bit of wriggle room too?
I'm not sure exactly what...
Well, you will get the paperwork, let's just say on the 31st, well, on the 31st. You have a short period to consider whether it's actually up to scratch.
Yes.
The day you get it, can you seek the minister's wriggle room to say, hey, 59 people, it's about to happen, get yourself ready. And take that on advice.
Particularly given the 59 people.
With this 59 people, does anyone else in the community get to put a submission in, even though they didn't put one in the first place? Even though we don't get notified, but could we still put a submission?
That's a good question. As
I'll
far
always
as
ask the
I
question.
know,
If I knew the answer, I wouldn't ask it.
as far as I know, yeah, the way I see it, yes, it would be open to anybody else to
We don't get notified, so this we know what's a 59.
we don't, yes, we don't need to notify, we only need to notify the 59, that's the catch.
Yeah.
And the other thing is,
So we have to find out some way or another when it's coming out.
So in other words, if the community council announces it, that's considered okay, and anyone who hears it can send something in?
That's what the community council will decide whether
and
to
while
announce
we're
it.
talking
Because I think this is a very
59
important
Yeah, no,
issue.
thanks
This
for that, yeah.
very important issue. It's not that it's something, you know, it's not saying nothing's important, but this is extremely important, this thing.
Yeah, yeah.
Can I just say one last thing, George? I know you've said that the minister doesn't have the power to place the city impact track, but I've got the act here and I'm absolutely certain that the minister does have that power. So I mean, I just want to flag that and put it on the record that in my view that's
The minister has
inaccurate.
the power to put an application in the impact track if it's a new year. Once it's decided, then it's a reconsideration application, it has to stay in that track.
But you referred to section 113.
Yes.
Section 113 is actually quite brief and it says absolutely nothing.
Well, 1134 says if an assessment track applies to development proposal, it is an assessment track, and that track must be followed in assessing the development application for the proposal. I think that's pretty clear.
Except that subclause 3 says that subsection 2 does not apply if after the application is made, the minister makes a declaration in relation to the proposal.
But in this
to
case, the
declare-
minister hasn't made a declaration, so it won't apply.
And
But he
yet they
could.
should.
But the decision has already been made, so, and in this case, if an assessment track applies, I think, I'm happy to discuss that separately with you, if you want some clarity on it, but that is.
Okay, are there other questions?
Just flag.
Well, I just want to check, Alistair, are you happy?
Yeah, of course, yeah.
Okay, just in case anyone has any burning issues before they go, because they are going to be going soon. Anyone else have any questions regarding the Coles-Doma DA?
This is not a technical question,
Yes.
and it may just require you to say, I can't comment on that. Coles, right throughout this country, build lots of supermarkets. And more often than not, they seem to fit in with the local environment. This one was a huge box that had no relation at all to the rest of the environment in which it was being built. Therefore, the logic is there is something wrong with the planning legislation that would allow that proponent to think that that's okay to put forward. There must be something, what allows a proponent to think that such a huge box is fine? Whereas the same proponent elsewhere in the country deals with local councils and say, no, the front will be 1 or 2 stories and you may go higher behind and all those sorts of things, but stay within the streetscape. This one is not within the streetscape. This is like setting the streetscape for the future. 8 stories, solid. There's something wrong with our planning laws that allows a developer to do what they do, use the laws to come up with that.
We take note of that. I'm definitely not going to respond to that.
Sorry, Leon?
I'd just like to remind you that our planning system, thanks to George, did not allow them to get away with it.
No, but technically he didn't actually say don't build 8-story block. He just said it's an aesthetics thing around here. But effectively, if they had the right architect, they could deal with what you knocked them back on and still come back with a 8-storey block, which has nothing to do with the streetscape. There's something wrong with the system that allows such a thing. Yet many local councils around the country will knock such a thing back saying they fit the streetscape. And Coles do it, but they're not doing it here because they've been asked to.
That might be something you might want to say for your representation.
Okay, Jay, I guess Jay will be the final question? Okay, go.
I've heard that someone that works at ACPLA is now working at Knight Frank and that they were involved in it. Is there a conflict of interest in any way?
No, there's no conflict of interest. The person you referred to has declared a conflict of interest right at the start.
Yeah.
He wasn't involved in any way in the previous decision, and neither the assessment or anything. So.
Have they been to any Liberal fundraisers?
I'd like to move a vote of thanks
Yeah.
to George.
Okay, thank you very much, George and Lisa. Appreciate it.